compelling than any other interest the state could have?
No, Your Honor, we're not, certainly not. We are saying the interest in marriage and the state's interest, society's interest in what we have framed as responsible procreation is vital. But at bottom, with respect to those interests, our submission is that same-sex couples and opposite-sex couples are simply not similarly situated. But to come back to your precise question, I think, Justice Sotomayor, you're probing into whether or not sexual orientation ought to be viewed as a quasi-suspect or suspect class. And our position is that it does not qualify under this Court's standard and traditional tests for identifying suspectedness. The class itself is quite amorphous. It defies consistent definition, as the plaintiff's own experts were quite vivid on. It does not qualify as an accident of birth, immutability in that sense. Again,
so what I don't quite understand it. If you're not dealing with this as a class question, then why would you say that the government is not free to discriminate against them?
Well, Your Honor, I would think that I think it's a very different question whether or not the government can proceed arbitrarily and irrationally with respect to any group of people, regardless of whether or not they qualify under this Court's traditional test for suspectedness. And the hypothetical I understood you to be offering, I would submit, would create unless there's something that is not occurring to me immediately, an arbitrary and capricious distinction among similarly situated individuals. That is not what we think is at the root of the traditional definition of marriage.
Mr. Cooper, could I just understand your argument? Reading the briefs, it seems as though your principal argument is that same-sex and opposite-sex couples are not similarly situated because opposite-sex couples can procreate, same-sex couples cannot, and the state's principal interest in marriage is in regulating procreation. Is that basically correct?
Your Honor, that's the essential thrust of our position, yes.
Is there — so you have sort of a reason for not including same-sex couples. Is there any reason that you have for excluding them? In other words, you're saying, well, if we allow same-sex couples to marry, it doesn't serve the state's interest. But do you go further and say that it harms any state interest?
Your Honor, we go further in the sense that it is reasonable to be very concerned that redefining marriage as a genderless institution could well lead over time to harms to that institution and to the interests that society has always used that institution to address. But, Your Honor,
could you explain that a little bit to me, just because I did not pick this up in your briefs? What harm you see happening, and when and how, and what harm to the institution of marriage or to opposite-sex couples? How does this cause and effect work?
Once again, I would reiterate that we don't believe that's the correct legal question before the Court, and that the correct question is whether or not redefining marriage to include same-sex couples would advance the interests of marriage as opposed to —
Well, then are you conceding the point that there is no harm or denigration to traditional opposite-sex marriage couples? So you're conceding that?
No, Your Honor, no. I'm not conceding that.
Well,
and I've got two
then
answers.
It seems to me that you should have to address Justice Kagan's question.
Thank you, Justice Kennedy. I have 2 points to make on that. The first one is this. The plaintiff's expert acknowledged that redefining marriage will have real-world consequences, and that it is impossible for anyone to foresee the future accurately enough to know exactly what those real-world consequences would be. And among those real-world consequences, Your Honor, we would suggest are adverse consequences. But consider the California voter in 2008 in the ballot booth with the question before her whether or not this age-old bedrock social institution should be fundamentally redefined, and knowing that there's no way that she or anyone else could possibly know what the long-term implications of a profound redefinition of a bedrock social institution would be. That is reason enough, Your Honor. That would hardly be irrational for that voter to say. I believe that this experiment, which is now only barely 4 years old, even in Massachusetts, the oldest state that is conducting it, to say, I think it better for California to hit the pause button and await additional information from the jurisdictions where this experiment is still maturing.
Mr. Cooper, let me give you one concrete thing. I don't know why you don't mention some concrete things. If you redefine marriage to include same-sex couples, you must permit adoption by same-sex couples. And there's considerable disagreement among sociologists as to what the consequences of raising a child in a single-sex family, whether that is harmful to the child or not. Some states do not permit adoption by same-sex couples for that reason. I don't think we know the answer to that. Do you know the answer to that? Whether it harms or helps the child?
No, Your Honor. And there's
but that's a possible deleterious effect, isn't it?
Your Honor, it is certainly among the...
Wouldn't be in California, Mr. Cooper, because that's not an issue, is it? In California, you can have same-sex couples adopting a child.
That's right, Your Honor. That is true. But Your Honor, here's the point.
It's true, but irrelevant. They're arguing for a nationwide rule which applies to states other than California, that every state must allow marriage by same-sex couples. And so even those states that believe it is harmful, and I take no position on whether it's harmful or not, but it is certainly true that there's no scientific answer to that question at this point in time.
And that, Your Honor, is the point I am trying to make. And it is the respondent's responsibility to prove under rational basis review not only that there clearly will be no harm, but that it's beyond debate that there will be no harm.
You are defending, you are opposing a judgment that applies to California only, not to all of the states.
That's true, Your Honor. And if there were a way to cabin the arguments that are being presented to you to California, then the concerns about redefining marriage in California could be confined to California, but they cannot, Your Honor.
I think there's substantial there's substance to the point that the sociological information is new. I mean, we have 5 years of information to weigh against 2,000 years of history or more. On the other hand, there is an immediate legal injury or legal what could be a legal injury, and that's the voice of these children. There are some 40,000 children in California, according to the Red Brief, that live with same-sex parents. And they want their parents to have full recognition and full status. The voice of those children is important in this case, don't you think?
Your Honor, I certainly would not dispute the importance of that consideration especially in the political process where this issue is being debated and will continue to be debated, certainly in California, is being debated elsewhere. But on that specific question, Your Honor, there simply is no data. In fact, their expert agreed there is no data, no study even, that would examine whether or not there is any incremental beneficial effect from marriage over and above the domestic partnership laws that were enacted by the state of California to recognize, support, and honor same-sex relationships and their families. There's simply no data at all that would permit one to draw that conclusion. I would recall, Justice Kennedy, the point made in Romer that under rational basis review, a provision will be sustained even if it operates to the disadvantage of a group, if it otherwise advances rationally a legitimate state interest.
Mr. Cooper, we'll afford you more time. You shouldn't worry about losing your rebuttal time. Please continue on.
Yeah, as long as you're on that, then I'd like to ask you this. Assume you could distinguish California. Suppose we accept your argument, or accept Justice Scalia's version of your argument, and that distinguishes California. Now let's look at California. What precisely is the way in which allowing gay couples to marry would interfere with the vision of marriage as procreation of children that allowing sterile couples of different sexes to marry would not? I mean, there are lots of people who get married who can't have children. And so take a state that does allow adoption and say, what's the justification for saying no gay marriage? Certainly not the one you said, is it? Am I not clear? Look, you said that the problem is marriage as an institution that furthers procreation.
Yes, sir.
And the reason there was adoption. But that doesn't apply to California. So imagine I wall off California and I'm looking just there where you say that doesn't apply. Now what happens to your argument about the institution of marriage as a tool towards procreation, given the fact that in California, too, couples that aren't gay but can't have children get married all the time?
Yes, Your Honor. The concern is that redefining marriage as a genderless institution will sever its abiding connection to its historic, traditional, procreative purposes, and it will refocus the purpose of marriage and the definition of marriage away from the raising of children and to the emotional needs and desires of adults, of adult couples.
Well, suppose a state said, Mr. Cooper, suppose a state said, because we think that the focus of marriage really should be on procreation, we're not going to give marriage licenses anymore to any couple where both people are over the age of 55. Would that be constitutional?
No, Your Honor, it would not be constitutional.
Because that's the same state interest, I would think. You know, if you're over the age of 55, you don't help us serve the government's interest in regulating procreation through marriage. So why is that different?
Your Honor, even with respect to couples over the age of 55, it is very rare that both parties to the couple are infertile. And the traditional
no, really, because if a couple — I can just assure you, if both the woman and the man are over the age of 55, there are not a lot of children coming out of that marriage.
Your Honor, society's interest in responsible procreation isn't just with respect to the procreative capacities of the couple itself. The marital norm, which imposes the obligations of fidelity and monogamy, Your Honor, advances the interest in responsible procreation by making it more likely that neither party, including the fertile party to that.
Actually,
Mr.
Cooper, I suppose we could have a questionnaire at the marriage desk when people come in to get their marriage. You know, are you fertile or are you not fertile? I suspect this Court would hold that to be an unconstitutional invasion of privacy, don't you think?
Well, I just asked about age. I didn't ask about anything else. That's not we ask about people's age all the time.
Your Honor, and even asking about age, you would have to ask if both parties are infertile. Again,
Strom Thurmond was not the chairman of the Senate committee when Justice Kagan was confirmed.
Very few men outlive their own fertility. And so
just a couple where both people are over the age of 55. Where both people are over the age of 55.
Yeah. And Your Honor, again, the marital norm, which imposes upon that couple the obligation of fidelity.
I'm sorry.
Where is that?
I'm sorry. You can finish your answer to Justice Kagan.
Yes, is designed, Your Honor, to make it less likely that either party to that marriage